Good morning, everyone. Welcome to the second part of a new series that Parkinson's Community Los Angeles is conducting for members of the Parkinson's community, not only in the greater Los Angeles area, but now with the electronic reach of Zoom and other devices, we find that we are including people in other time zones in other countries and the like. So to all who are tuning in, welcome to you today. This is, as I said, in a series, but it's the part two of financial planning that we've undertaken. The first part had to do with the dealing with financial fitness, financial strength in the particular context as we are so directly focused with people with Parkinson's or family members or others that treat and care for people with Parkinson's. And the first segment of this was very well received, and I have no doubt that this next part, given to us by Eric Bergman, will be equally well received and is equally important to individuals, to all individuals really, but to wake up to individuals that may have many other things on their plate and may not be thinking about the future in terms of estate planning and the like. Before I go further in that, let me introduce myself. I'm Stephen Rubin. I am a board member of Parkinson's Community Los Angeles, which we refer to as PCLA. My wife, unfortunately deceased, was a founding member of PCLA, and I stepped into her shoes about a year ago, and have been very happy to serve and to see the miraculous growth, really, of PCLA in the last year or two. I'm an attorney by profession, and I've been active in channeling that growth of PCLA, a growth that is greatly dependent on the support of those who are tuning in today. We've had a wonderful fundraising year in 2021. We hope to replicate it and improve on it in 2022. And it's all about you, how much you get from programs of this sort, and your assistance to make this happen for us. So if you would, or if you have and want to repeat, you can go to our website, pcla.org, where there is clear instructions on how to make donations to the organization. Before I introduce Eric, let me get to a couple of housekeeping notes which are written for me. We are recording today's event for the PCLA YouTube channel. And I would direct you to that channel for a lot of other content that we have created over the last couple of years. And you can get to it at YouTube by going to Parkinson's Community LA. Please stay muted throughout the program so that we don't interfere with or confuse the presentation. There'll be time for questions at the answer. You can submit them in the chat function on your screen at any time. And if typing is difficult for you, we will ask for spoken questions from the audience at the end, so you can hold those questions for then. And it goes without saying, there are a lot of people coming online. Please keep your questions and the topics to this point, so that not only you, but everyone else who is joined on can benefit from your question and the answers that Eric provides. So with that, please help me welcome Eric Bergman, an attorney in California and with the law firm of Weinstock and Mannion, a law firm of specialty in estate planning and financial matters, and with a broad range of experience, including the kinds of issues that arise with people who may be impaired, who are reliant on caregivers, on family members, and the like, all of which factors into financial and estate planning. Eric is an associate at the firm. This is what he does. He's actively engaged in it all the time. He should be able to answer your questions, but again, keep them on point and in general, not a specific problem that you may have, but one which would benefit the audience. And with that, Eric, let me turn the microphone to you.
Great, thank you very much for the introduction, Stephen. Let me get my slideshow up and running so we can get started. Okay. All right, yeah, once again, thank you, Stephen, for the introduction, and good morning, everyone. I would like to thank you for attending today's event, and a big thank you to PCLA for having me. I really do appreciate the opportunity. Like Stephen said, my name is Eric Bergman. I'm with the law firm of Weinstock Mannion, and I'm an estate planning attorney. This is my specialty, and as a note, I am doing this presentation from home, and I do have a 5-month-old playing upstairs, sometimes crying upstairs. So just in case you're wondering what that noise in the background is, I do appreciate your patience with that. So let's get started on today's topic. So why do you need an estate plan, and what does a well-rounded estate plan entail? The short answer is everyone should have a well-rounded estate plan in place to ensure that you and your family are provided and taken care of, not only upon death, but upon those times in which you may become incapacitated. As you'll see during this presentation, this will require much more than just a mere will in order to achieve this result. So what I kind of want to start off this presentation with is, what does a world look like if you don't have any type of estate plan in place? You don't have a will or a trust or any of those other ancillary documents that make up a well-rounded estate plan. Well, upon your incapacity, a court will likely need to get involved to appoint someone to handle your personal and financial affairs while you're unable to. And that is, a result you want to avoid as much as possible. Getting a court involved is always going to be timely and costly, and your loved ones are going to have to wait some period of time in order to be taken care of. And if you don't have any type of estate plan upon your death, the state of California is going to decide how your property will be distributed upon your death to your family via what is known as the intestate succession laws outlined in the California Probate Code. Basically, the state is taking its best guess on how the average person would prefer their estate to be distributed. A very simple outline is provided in this slide. Let's take a quick look at that. So assuming you don't have any sort of estate plan in place, no will, no trust, and you are married but have no children, the state says all of your assets are just going to go to your surviving spouse, free of trust and outright. If you are, instance, for married and with children, it's going to depend on the type of assets that you have in your estate. If it's community property assets, all of those assets will go to your surviving spouse, free of trust, and then the separate properties is actually going to be divided. Some is going to go to your spouse, some is going to go to your children. And so if you take a look at this, this may not be the result that you want. You may want all of your assets to go to the surviving spouse, regardless if it's community or separate property. You may have children who have special needs, and you may want it to be held in trust. It's just, for most people, this isn't the result that they want. And on top of all that, if you don't have any sort of estate plan in place upon your death, all those assets, in order to get to your loved ones, are going to need to go through a probate process. And I'll discuss that in a little bit more detail later, but it's a timely and expensive proceeding that you really want to avoid at all costs. So what if you decide to do the most basic type of estate plan and just have a will in place? Well, first of all, what is a will? A will is a document that takes effect upon the testator's death. The testator is another name for the person who creates the will, and directs the disposition of his or her assets that are not otherwise disposed of by beneficiary designations, such as in retirement accounts or life insurance policies, by operation of law, such as real estate held as joint tenancy, or through a revocable living trust, which we'll of course discuss in a little bit. So what happens upon your incapacity if only you have a will in place instead of a more well-rounded estate plan? Well, a will only takes effect upon death. It does not deal with incapacity issues at all. So if you want to do incapacity planning, which would be very important, a will alone is not going to do anything for you in that respect. And then what happens upon death if you have a will? Well, your assets will be distributed as stated in your will. You're not going to be subject to the intestate succession laws dictated by California, but the assets will still need to go through the probate process. So let's take a look at what probate actually is. So probate is the legal process of administering a deceased person's estate after his or her death. If you have a will, probate will also involve proving that your will is legally valid, executing your instructions, and paying the applicable taxes. So there are many, many disadvantages to probate, which I'm sure you've heard before, but let's go over them in details just so you really understand why this is something that should be avoided. First off, it's a very lengthy, timely process. The average time to complete a probate administration is about 12 to 18 months after the death of the decedent, because each step of the administrative process must be approved by the court by filing petitions. And in addition to that, the executor of your estate, the person that's going to manage your estate upon your death, if all you have is a will, doesn't even take possession of the decedent's assets until 1 to 3 months after death. This is going to make it incredibly difficult to pay bills, to make sure your loved ones have access to your assets upon your death. So a big reason why you want to avoid probate at all costs. In addition, it's costly proceeding. There's filing fees, mandatory appraisals of assets, executor fees, and attorney fees that are dictated statutorily. So to give you an example, I recently had a probate of a pretty small estate, $500,000. They owned a home, and basically that's it. The mandatory attorney fees alone was $16,000 to probate, and there's definitely fees on top of that. I think it ended up being about $30,000 to probate the entire estate. And if you have an estate plan in place, if you go to an estate planner who knows what they're doing and does a good job, the most basic estate plan you'll probably be paying like a fraction of that amount, maybe $5,000, give or take, these days. Also, the probate is a public proceeding. All documents filed with the court are public, as anyone can request copies of documents filed in a probate proceeding. This is including copies of your will, the inventory and appraisal filed to identify the assets of your estate, all creditors' claims that are filed against the estate, etc. And finally, there are very strict creditor notification requirements. And there's a duty to inform all creditors and give them 4 months to file a claim against the estate. So there's, as you see, a large slew of reasons why you want to avoid the probate process. And that kind of brings us to our next topic, why you should have a revocable living trust and other estate planning documents, which we'll get to in a bit. So yeah, how do you avoid all the issues that are raised when you die intestate or only have a will? Well, you form a revocable living trust and prepare the other ancillary estate planning documents that make up a well-rounded estate plan. So first, what is a revocable living trust? It's an agreement between the creator of a trust, also known as a settlor or a trustor, with another person, in other words, the trustee, whereby the trustee holds on to the property for the benefit of the trustor during his or her lifetime, and then upon the trustor's death or incapacity, distributes the assets of the trust in accordance with the terms of the trust to basically the trustor's spouse or children or other beneficiaries. Now, there's two types of revocable living trusts that I kind of want you to be aware of. There's a single trustor trust and a dual trustor trust, and they operate on various phases. So I'll go over this very quickly. It can get very complex. but I just want to give you the basic outline of what this looks like. So a single trustor is usually created by an unmarried person. They have other roles, especially if you have a lot of separate property, but we'll just talk about the situation in which you have a single trustor for an unmarried person. During the first phase, this is how the trust is administered during the trustor's lifetime. During this first phase, it's completely amendable and revocable by the trustor. The property held in the trust is held for the benefit of the trustor, and the trustor is going to have complete access to the trust assets during their lifetime. But this is the key aspect of phase one. Upon incapacity, a successor trustee will step in to care for you and your children upon incapacity, without having to go to court, without having all the costly, timely aspects of having to administer your estate during your incapacity. Someone will step in immediately and be able to handle your trust assets for the benefit of you during your incapacity, and also help out your family using trust assets as well. Phase two is upon the trustor's death, the irrevocable living trust now becomes irrevocable, and then the assets are distributed to your named beneficiaries in accordance with whatever terms you decide with you and your family. And that can be as complex or as simple as you like, depending on various needs, which we'll discuss in a little bit. The other type of trust is a dual trustor trust, and that's usually created when you have two trustors who are married. Phase one is how it's administered during the joint lifetimes of the trustors. So during phase one, the trust will be held for the benefit of both trustors. It'll be fully revocable and amendable by the trustors, and upon incapacity, the successor trustee will step in, and usually in this case, it will be the spouse who's not incapacitated, to care for you, that spouse, and your children. Like I said, immediately. There's going to be no need for court involvement to be able to distribute assets to take care of you while you are incapacitated. Someone will have access to your assets immediately to make sure that you and your family are taken care of. Phase two is what happens upon the first trustor's death. So when the first trustor dies, then the entire trust is held for the benefit of the surviving spouse. And similarly, if the surviving spouse becomes incapacitated, the trust will be held for the surviving spouse and their family to make sure that the assets are there for them when they need it. And then phase three is what happens upon the surviving spouse's death. And similarly, as phase two for the single trustor trust, the entire trust becomes irrevocable, and the shares are distributed to the beneficiaries in whatever manner you and your family decide is appropriate for your circumstances. So that's basically what a revocable living trust does and what it looks like. Let's go into the advantages of having a revocable living trust. Well, first and foremost, it's probate avoidance. There is going to be little to no court involvement during each of those phases and upon incapacity. In addition, there's going to be a faster administration period. Assets get to you and your loved ones upon incapacity or death in a matter of months, if not sooner. And the trustee has immediate control of the assets upon death and the incapacity of the trustor. So if bills need to be paid, if mortgages need to be paid, the trustee can step in and make sure that happens, and it's peace of mind for your family. But another key aspect is incapacity planning. So a will, as I said earlier, takes effect only upon death. It's not going to do anything for you and your family if you become incapacitated. Trusts are often drafted to ensure that you are taken care of upon incapacity. So as I said earlier, upon incapacity, however that is defined in the trust, and we'll talk a little bit about that later, the successor trustee will step in. Whoever you name to be successor trustee will step in, either your spouse or some other trusted family member or friend, to ensure that the trust assets are distributed to you for your benefit and for the benefit of your spouse and the benefit of your children, usually minor children, immediately upon your incapacity. As I mentioned earlier, it's also a cheaper alternative than going through the probate process. The cost of putting together an estate plan, especially a revocable living trust, is going to be a fraction of the cost of going through probate. Additionally, having a revocable living trust in place is private. There's going to be no public disclosure of your trust or its assets to anyone. The only people that will know the terms of your trust really is your attorney and the beneficiaries of the trust upon your death. As under California Probate Code, they're required to get notice of the trust and its terms before distribution. There's also less stringent creditor notification. There's also the possibility of creditor protection to your spouse and your children if structured appropriately. So if your spouse or children run into any creditor issues, you can structure the trust in a way so that upon your death, if it's distributed to them, their creditors cannot get to those assets. And you make sure that they are taken care of and they have the assets they need to live a long and healthy and prosperous life. And then finally, and I think this is a really, really big one, it's peace of mind. Your family has enough to worry about when they lose a loved one or when a loved one's going through incapacity issues. And this having this in place makes the process just a little bit easier, really. So this is my recommendation for when to use a revocable living trust. If you are diagnosed, a will is going to be an insufficient tool for managing assets during your incapacity, and a revocable living trust will be necessary so that a successor trustee can step in immediately and without court involvement to manage the trust assets on your behalf and the benefit of your family. So typically probate is only required if you have assets greater than $160,000. And if it's less, there's some court involvement, but it's a very truncated process. But if you're worried about your assets being handled during your incapacity, then regardless of the size of your estate, having a revocable living trust in place, as well as other ancillary estate plan documents, which I'll discuss in just a bit, is going to be key and necessary, in my opinion. So let's talk about those other key estate planning documents that I mentioned earlier. So the first one is known as a general durable power of attorney. In this document, you're going to name agents to act on your behalf when you're incapacitated with respect to a broad range of financial matters that will fall outside of the trust. And this will include transferring assets to the trust, accessing your safe deposit boxes, signing tax returns, making decisions regarding distributions of retirement benefits, collecting and deposit money into bank accounts, making gifts to your children, paying tuition and medical expenses for your children and for yourself, really. And just basically this allows your agent to step in immediately upon your incapacity to handle the day-to-day management of your financial life. The agent will usually take this general durable power of attorney to the bank, and it'll give them the power to manage your assets. They'll also take it to, if you have a brokerage account, they'll take it to the broker to ensure that they have control over that and make sure the assets are distributed for the benefit of you and your family. As an alternative, usually this document is called a springing general durable power of attorney. And by that means it springs upon the creator of the document's incapacity. But you can make this document effective immediately. And that may be recommended if determining what an incapacity is a problem, which can be sometimes. So under certain circumstances, you may want to consider making this document effective immediately rather than just be springing. Another key estate planning document as part of a well-rounded estate plan is what is known as an advanced healthcare directive. So in an advanced healthcare directive, you will appoint what is known as a healthcare agent and provide them with the authorization to make certain medical decisions on your behalf when you're unable to. And this would be whether or not you want to be an organ donor, decisions regarding life support, and handling the disposition of your remains, as well as just communication between you and your doctor and your medical providers during the time when you're unable to handle this communication on their own. In addition to the Advanced Healthcare Directive and General Durable Power of Attorney, it would also be key to have what is known as HIPAA designation documents. So you may be familiar with HIPAA. So the Health Insurance Portability and Accountability Act puts very, very strict requirements in the dissemination of health information by healthcare providers. And these HIPAA documents would provide your representative, known as a personal representative in these documents, unrestricted access to your health information, such as medical records and medical billing information. And these documents would also authorize your personal representative to release your health information to healthcare providers as needed. This will be very key in your loved one's ability to manage your health care when you're unable to do so. And finally, as part of a well-rounded estate plan, and I think this is pretty key, is to make sure you have deeds and other transfer documents executed at the same time. And this is key because your revocable living trust is only going to do as much work as the assets that the trust owns. The trustee is only be able to step in place to manage your assets if your assets are titled in the name of the trust. So if you have real property, you want to make sure that once your revocable living trust is created, that the property is formally conveyed into the trust, and that other assets are titled in the name of the trust, such as brokerage accounts, bank accounts, savings accounts. If you have retirement benefit plans, you want to make sure that the plan administrator changes the beneficiary designations for those retirement plans. If you have life insurance policies, you want to make sure that the contingent beneficiary of those life insurance policies is changed to the name of the revocable living trust. So upon your death, you know that those assets are being held and distributed in accordance with the terms of the trust. If assets are not titled in the name of the trust upon your death, then those assets unfortunately will have to be probated. However, estate planning attorneys, as part of a well-rounded estate plan, would also include, I didn't list it here, but what is known as a general assignment to the trust. And if you have a general assignment to the trust, those assets that aren't included in the trust at the time of your death can later be transferred into the trust through a truncated probate proceeding. So you're not going to have to go through a full-fledged probate proceeding with that massive cost and time. And you'll be able to go to court with that general assignment and say that all these assets were intended to be as part of the trust upon the death, and it'll be a truncated proceeding to get those assets in the trust so they can be managed in accordance with the terms that you decided. Kind of wanted to go over some other relevant issues with respect to creating an estate plan that you should discuss with your estate planning attorney. So first and foremost, so depending on your financial situation, an attorney may not recommend preparing a revocable living trust. As stated earlier, if you have assets under about $160,000, a revocable living trust may not be necessary. However, for someone who is diagnosed, a revocable living trust will be a key document for incapacity planning. So letting your drafting attorney know of your diagnosis is going to be very important for structuring an estate plan appropriate for you and your family. Another key issue is how incapacity is defined in the trust document and in the general durable power of attorney. Your trust and financial power of attorney will come into play when you become incapacitated, and this can mean many different things. And you should discuss this with your attorney to find out if it meets you and your family needs. I put some sample language in here, as this is the type of language that we put into our general durable power of attorneys to define what incapacity is. And it provides like a process for determining it. And usually it only involves having a letter from your physician stating it otherwise. And if there's any dispute between your agent designated in your general durable power of attorney and you, there's a process for figuring that out on a timely basis without having to get a court involved necessarily. But this is key information that you're going to want to discuss with your estate planning attorney to make sure it meets the needs of you and your family. Also, handwriting issues. So what I would recommend for people who have been diagnosed is to have your lawyer and the disease has progressed to a certain extent, is to have your lawyer prepare several formal witnessed and notarized affidavits, which you sign at different points during the day to document the changes in your signature. And this can be helpful when trying to convince a bank, for example, that your signature is real, even though it differs from the signature card that they have on file. And also, just so you know, under the California Probate Code, when you sign these documents, the California Probate Code doesn't require a proper signature per se. A mere mark is sufficient. So if you're having trouble signing your name at any point in time as this progresses, a mere mark is more than sufficient. But it's also good to have these formally witnessed notarized affidavits of your various signatures in case there's any dispute down the road. And finally, you should talk to your estate planning attorney regarding special needs trusts. So a special needs trust ensures that the trust is drafted in a way to supplement and not replace government benefits. Because if you're getting too much benefit from a trust that's created for you, and you are also receiving government benefits at the time, there are strict rules that are promulgated that say that you may be getting too much benefit personally and from other areas that the government benefits will cease. So there are ways we can structure these trusts to ensure that we supplement and do not replace government benefits. So one last point I kind of want to go over. So another key issue you should have in mind if you are fortunate enough to be in such a position is advanced estate planning. Now, advanced estate planning techniques come into play when you have an estate larger than currently $12,060,000 per person. Each of you have that exemption from gift and estate tax. And if you have an estate larger than that or at or around that, there are certain advanced estate planning techniques that minimize estate tax burden on your family and children by using charitable trusts and irrevocable trusts. Those types of planning can get very complex and would be subject to an entirely new and different presentation, but it's something you should have in mind in case this applies to you. So yeah, thank you. That ends my presentation for today. Thank you for attending, and I look forward to answering any questions or comments you guys have in just a bit. So appreciate it, everyone.
Thank you very much, Eric.
Absolutely.
That was, as anticipated, highly informative, and also you drilled down a bit. And as I mentioned, I've recently experienced this process in my own marriage and with my wife's passing. And to those who are listening in who haven't been exposed to this before, and even those who may have had some practice in these documents, it seems overwhelming. It's just layer after layer of laws and regulations and taxes. And if you slip up, the world is going to come to an end and all the rest of it. And I just wanted to say, not so much as a lawyer, but as an individual within the Parkinson's community, that getting a guide through this makes all the difference, because it's overwhelming until you see the logic of it and the interconnection of it, and then you can work through it. And it's so vital to do that because there are deadlines. And some of those deadlines can be very arbitrary. And what you thought you were doing or what you thought you weren't doing, if you sit on various activities that are required, you may find that decisions have been made for you or for your loved one that you're not very happy with. The one other thing that I would say, and hearing you and talk about disability and the problems that arise from debilitating diseases such as Parkinson's, is that with medical care and with the progress of the disease, there may come a time when your loved one isn't able to make decisions. Dementia may sneak in. It may not be radical. It may not be the sort of thing that you say, oh boy, this is Alzheimer's or something of that sort. But from the law's point of view, it could be quite significant. And you can't wait for that. You can't assume that the world is on an even keel and things are going to stay as they are. So if I could add one message to yours, it's urgency, that you don't procrastinate. You bite the bullet because you'll find out the bullet isn't that big or that hard once you get into it. So with that, I do want to thank you again, Eric, for going through this. You were very succinct, organized, and I think you gave us the landscape to work through. There are a couple of questions that we have in the chat room. I guess I can read these. There aren't that many, so we could take them in order. Let's see. One question, I guess Judy Yaris, another board member and officer of PCLA, asked, do you still need an advanced care directive from an attorney if you have one on file at your medical center? And maybe you can explain to us again what the healthcare directive is and what its function, and whether you need multiple copies.
Sure. So once again, the Advanced Healthcare Directive is a document whereby you appoint a healthcare agent to make healthcare decisions on your behalf when you're unable to. Lots of healthcare providers provide their own healthcare directive and have you fill out a form that they may have on file before you have an appointment with a new doctor, et cetera. But those documents they're kind of placeholders, I would say. I would really recommend you use one from an attorney, an estate planning attorney, so they can be customized for your family's needs and desires and your personal circumstances. Because one that's provided by a healthcare provider is going to be a form document that's not customized for you. And the Advanced Healthcare Directive that you'd had from an attorney would override. The documents specifically say that it overrides any other healthcare directive that you may have signed in the past. So you have one document that you could rely upon. And then that document, there's a program, I think with the California Secretary of State, where you can upload that Advanced Healthcare Directive. So a lot of your healthcare providers can have easy access to your Advanced Healthcare Directive if the time presents itself.
And especially helpful if you're asked for the directive at a time of stress, which is not uncommon.
Oh, for sure.
To have a ready answer to it and not have to deal with that kind of rigmarole.
Certainly. And what I would definitely recommend is whoever you name as your successor healthcare agent, it's usually going to be, of course, your spouse first or other friends in the family afterwards, that they're aware that this document exists and they know where to find it and that they're okay with serving in that role. So, because you don't want to appoint someone and then them not be comfortable with it, and then you have no one appointed afterwards that you trust. Because if you don't have anyone appointed, then you're not going to have anyone to step in and play that role when you need it most. So make sure that your named healthcare agents are aware that the document exists, they know where to find it, and that they're comfortable with serving in these roles.
This is a tough conversation for many people.
Sure.
This is a big topic, but an essential one. Sandy Rodley commented, and I thank her for this, that while I was saying we're dealing with the peels of an artichoke in terms of the detail of the estate planning laws, this has been and will be recorded and available for replay. So people who might want to have a pad and paper in hand and go through it more slowly and pause at particular times definitely have that opportunity. And it's a good one, I would think. To get it all on one go is maybe too scary and has the adverse effect of convincing people just to walk away from it in horror. Another question, roughly how much, this from Angela Chang, roughly how much is the attorney fee for setting up a revocable living trust in California? So can you put a ballpark to it?
It's a wide range, and it really depends on the attorney and the type of firm and the location. For my firm and my firm, One Stock Companion, we do a lot of really advanced estate planning for wealthy individuals. So our fees are a little bit higher than some others, but for the most basic plan, it's usually $4,000 to $5,000. The more customization and the more detailed terms that we need to add to the trust, depending on your circumstances, in the circumstances of your family, it could, easily go up to much higher. But I really wouldn't recommend you going to like LegalZoom or anything. And I'm not just saying that because I'm an estate planning attorney. I've seen those documents and I've seen how they fail people who how they put them together and they try to administer the terms at the time of death, and it just doesn't work for the family because they don't have an active eye looking at the family circumstances and customizing the provisions to provide for the needs of the families as they should be. So I really, really recommend everyone to actually reach out to an estate planning attorney, reach out to a couple, find one that you have good rapport with and you're comfortable with their fees, and make an appointment as soon as possible. Because like I said earlier, if you don't have an estate plan in place, it's just going to end up costing your family more money and more headache down the road, unfortunately, with our crazy probate proceedings in California.
There's so many aspects to this. One is those with assets and with family, and the opportunity to leave property to family members, usually children or grandchildren or the like. It's a legacy. But how many times have I heard within my circle and have read about botched estate plans, not even looking at tax consequences or the ease of moving assets, but that a child, for totally avoidable reasons, feels slighted. Yeah. And you you can't unring that bell once the estate is implemented. So it's another reason to think about this clearly. It is a legacy. It is your potentially, for some of us, children and grandchildren. And though it's costly at the outset, there are so many things that could go right if you do it right that make it important. So Sandy Rodley again asks, do you recommend, this to Eric, do you recommend that you put all assets into your trust, your will into your trust? Maybe you could clarify that. Banks, real estate, cars, etc. How much is appropriate to put into the trust and how much is de minimis?
So let me just address the trust versus will difference there. So you don't put any assets into a will. A will basically says any assets that are in your estate at the time of your death will be distributed in accordance with whatever the will says. So it's not a separate entity. A trust is a separate entity that can hold assets, and it's assets that you can put into the trust during your lifetime, so that upon your capacity or your death, the trust already owns everything. So there's not going to need to be a formal transfer of assets to anyone in order for them to handle those assets for your loved ones during such time. So a will, you don't transfer any assets to a will. You would with a trust. And what assets should those be? There should definitely be your bank accounts. They should definitely be your real property. They should be your brokerage accounts. They should be anything of assets of higher value. And all you need to do for that is to go to the bank, bring them a copy of the trust, and have them change title on the account. You did the same thing going to your broker to make sure that they change title on those brokerage accounts. With respect to real estate, as part of a well-rounded estate plan, the estate planning attorney will prepare a deed conveying your real property into the trust. And there's will be no issues with respect, if you have a current mortgage on the property, there's going to be no issues with respect to the lender just putting the real estate into the name of your trust. With respect to cars, there's such an easy process through the DMV to transfer title on a car upon death that it's really not worth it to retitle the car into the name of the trust. But also during the presentation, I mentioned retirement benefit plans and life insurance policies. Change the beneficiary designations, or I should say the contingent beneficiary designations, into the name of the trust. And yeah, so that for those larger assets, it's important to have them retitled to the name of the trust. And
me raise another asset that doesn't usually come up at the beginning, but could be quite important. It may have little to no value financially. The sentimental value could be over the moon. And there are people who sit in the lawyer's office and hear about bank accounts and real estate and things of that sort. And they're worried about their engagement ring or their grandmother's tea service that they've kept for their entire life or marriage or what have you. How are those kinds of assets dealt with?
so those assets, those are what are known as tangible personal property. And usually there's a specific provision in the trust document that outlines exactly how those types of items should be distributed. In addition, if there's specific items that you want to make sure go to a specific person, that can be outlined in the trust, or what you can also have is what is known as a personal effects exhibit, whereby after the trust is signed, you could fill out a document that says, I want this ring to go to my daughter, or I want this fine china to go to my friend, or even pets to a specific person. And that document could be signed and executed and filled out during your lifetime, long after the trust has been signed. So that, of course, can be changed and amended at your will. But other times, usually if you have children or if you have a spouse, the trust will usually say all of your tangible personal property will be distributed to your spouse upon your death. If you don't have a spouse, then it'll be distributed to your children in equal shares. And it'll be up to your children to determine how to divide the tangible personal property equally among them. And if they have a dispute, then there's usually a process outlined in the trust to resolve that dispute.
Good. Let's see, another question is by Patricia Ardent. If I end up in an assisted, this may, well, I'll give it to you, Eric. It may be a bit off the mark. If I end up in assisted living care and don't have a long-term care insurance, does California have laws that will prevent my spouse going broke? And I guess to bring it back to your topic, are there things you can do with estate planning to make sure your spouse doesn't go broke?
Oh, well, yeah, that question is probably more for an elder law attorney or a disability attorney. And I'm going to be, I have some good names that I'm going to provide to PCLA because I think they may do a presentation on that topic sometime soon. But from an estate planning perspective, I mean, it's important. That's why it's important to have a revocable living trust in place. So you ensure that all of your assets upon your death are held in trust for the benefit of your spouse, or even upon your capacity. So all the assets that you put in the trust, your personal residence, your tangible personal property, your bank accounts, your brokerage accounts, you ensure that by putting it into the trust, that when you can't access those assets because of your death or incapacity, that they're all held for the benefit of your spouse. And if you're, but that's not saying that those assets can be pulled from and used to pay for any sort of assisted care. So in order to ensure that a living spouse doesn't go broke during that time period, I think that question is probably better answered by an elder law attorney or disability attorney. There may be some California programs out there that assist those spouses.
Okay. This is again from Sandy. We have the documents in place. Let's assume a spouse passes. What does the other spouse have to do with regard to the trust now? Are there deadlines? Is there a chronology, a priority that needs to be followed, just generally, without getting into?
Right. So once a spouse dies and you have a revocable living trust in place, the first thing you want to do is contact your estate planning attorney who drafted the documents. There are going to be some administrative aspects, but the good thing about having a revocable living trust in place in that situation is that the administrative aspects that I'm kind of generally referring to are very, very minimal. Basically, the surviving spouse can have control over all the assets immediately. and just making sure that the proper procedures are met. You should speak to your estate planning attorney to go over those, but they're very minimal. It's mainly just ensuring that all of the assets are currently retitled so that you are the sole trustee. And it's a very simple affidavit change of trustee that would be recorded with respect to real property and simple documents that are sent to the banks and to your broker to ensure that those assets are retitled appropriately. Very minimal stuff. If you don't have a revocable living trust and everything has to be probated, of course, it's going to be a year and a half, a 2-year long endeavor instead of just a month or so.
Another question, and I think you've covered it in different places, and maybe can pull it together a bit now. How do I move, the question goes, bank accounts into a living trust?
So that's
specifically bank accounts.
Sure. So that's a very simple process. So usually a bank is going to require what is known as a trust certification. And a trust certification is just a document that is notarized. It says, this is the title of my trust. This is the legal title of my trust. It's a revocable living trust. And the important terms of the trust are provided in the attachment to the trust cert, where you basically attach just an abridged version of the trust that has the title page, the signature page, and the trustee powers. And you hand that over, the estate planning attorney will prepare that for you. You just hand that over to even a bank teller. If you walk in the bank and ask them, I'd like to retitle my bank account, this savings account, this investment account into the name of the trust. And it's a very quick process.
Are you going to be required to leave the trust document with the bank, do you think? Is it proper to get multiple signed copies, or is a photocopied signature for the bank sufficient?
So trust documents they're private documents, and you don't want everyone you don't want a lot of people to have access to those terms if you don't want them to, and you don't have to. So banks at the most may request an abridged copy of the trust, and all that will include is, I briefly mentioned earlier, is the title page of the trust, the signature page of the trust, and the provisions that provide the trustee powers. So you don't need to provide them with the entire thing, and you certainly don't need to provide them with those pages that outline the distribution of the trust assets to your beneficiaries.
Okay. Good. I don't see any other questions at the moment. Do we have any? Does anyone want to ask a question? Unmute and ask a question of Eric.
Yes. Hi, Eric. This is Rita.
Rita.
I had a question. Could you tell me the difference between the revocable living trust and this general durable power of attorney? What the difference is and the timeline?
Sure. So the revocable living trust is a document that creates a new entity to hold assets. So it's a document that you create, the trustor, or the person creating the trust creates, and they transfer assets into the trust, and the assets in the trust are going to be managed by the trustee of the trust. And the trustee of the trust in a revocable living trust is going to be the trustor most often. It's going to be you. And so you'll manage the assets as the owner, as the trustee of the trust. And the trust will provide that upon your death or incapacity, the assets will be managed in a particular way. And if you are unable to act as trustee in those situations, then you've named a successor trustee to step in your place immediately to manage the assets in accordance with the terms of the trust as you set forth in the document. The general durable power of attorney basically does the same thing as a trust does upon incapacity, but with respect to assets that aren't in the trust, and with respect to issues that aren't trust issues. So for instance, filing tax returns, you'll have someone upon your capacity to sign tax returns on your behalf because of the general durable power of attorney. They'll be able to access bank accounts that haven't been retitled into the name of the trust upon your incapacity. They'll be able to make gifts of assets to your children if they need it, or pay for their medical expenses or education. for those assets that aren't in the trust. And it's basically an instrument that's used to manage your day-to-day financial life for non-trust assets. Does that answer your question?
Yes, and thank you.
Absolutely, of course.
We have time for one or two more. Well, Eric, you've done a marvelous job, as this would indicate. Again, all of this program and the preceding financial planning program is available on YouTube by going to the PCLA Parkinson's Community LA site to do that. As a lawyer, I guess I should add that 2 cents. Eric, I thought you did a marvelous job in dealing with an area of the law that doesn't easily submit to straight answers and easy solutions at times. So on behalf of PCLA, I want to thank you for that. And I want to thank everyone who is on this Zoom meeting for joining us. I hope this was productive for you. It got you thinking, maybe got you motivated to go further and start the process of estate planning at a time when you can do it as a process and it's not rushed. You can do it methodically and get the most advantage of it. Today's program was brought to you by PCLA, as I've said. By donating to PCLA, you definitely are an integral part of bringing these programs available to our community, to yourselves, and as I said, to the larger community that PCLA is encountering through the use of Zoom and other devices. Our focus is local, but the topic that we are dedicated to, Parkinson's disease and its care and management, is global. And that's how we look at it. We're, as a group, and we consider everyone who participates an active member of the group. We're very motivated to make life and the issues that arise as manageable and as comfortable as possible. If you agree with the mission of PCLA, I again ask that you consider a donation to the organization, or maybe periodically a donation based on particular programs or information that you get. However, it's vital to us, and I hope and would say that you could see the fruits of it in programs like this. You could always reach out to PCLA at the website, as you see there, info@pcla.org. We also have a phone that is monitored and provides a whole variety of information and assistance that is geared to our mission in the Los Angeles community, but again, is not only Los Angeles, because Parkinson's is not only Los Angeles. So I think you might find it of value even if you are calling us from, I don't know, Stockholm or Rio de Janeiro, wherever, and we have had calls from all over the world. So to everyone, and to David, to Eric, thank you for attending. Stay safe in these unsafe times, and we hope to see you again soon on the PCLA channel. Good day.
Thank you so much for inviting me. Appreciate it.
Our pleasure.
Take care, everyone.